Morning, Chair.
Good morning. Thank you very much. I see Honorable Nzimande. Good morning. Yes, you're not audible now. You are muted.
Good morning, Chair, and everyone else. Thank you.
There we go. Thank you. Lovely background. Thank you very much. Good morning, Honorable Kahunda.
Good morning, Chair. Good morning to all members and officials. Thank you.
Thank you very much. Honorable Molokome, good morning to you.
Good morning, Chair, and good morning, honorable members and officials.
And once again, Honorable Molokome, also from our committee, we know you haven't been well of late. We're glad to see that you are back and you are on the mend. So thank you very much for joining our meeting, and the best wishes from our committee as well. As our committee.
Thank you, Chair.
Thank you very much. Honorable Teza, I see you on the platform. I saw Honorable Teza just now. Are you there?
Good morning,
No?
Chair. Morning
Good morning.
to the colleagues, and good morning to the officials.
Thank you
Thank
very
you.
much. Good morning. And I see our Chief Whip, Honorable Moimang.
Dumela Modulasetulo, and greetings to the colleagues from the Select Committee, the committee support team, and our guest. Greetings to all of you. Ke a leboga ra. Thank you.
I was going to say Lika Riteng, but let's not go into a conversation now.
Thank you.
Thank you very much. Have I missed any of the Select Committee members? If I have, just put your camera on and so we can recognize you. Great. Okay. Thank you very much. Mr. Mtelini, thank you very much. Welcome to you, Dr. Clark. I know Zolis was here as well. Mr. Ben and our committee support staff, thank you very much for being here. And then, are there any apologies, Mr. Mtelini?
Good morning, Chair and members, colleagues, and officials of the departments. We only received an apology from the Deputy Minister. There is no any other apology that we've received.
Mr. Mtelini, I think on the 24th of February, we also received an apology of Minister McPherson. He indicated that he is currently in the Middle East on duties that was approved by the President, so he won't be attending today's meeting as well.
My apology, Chair. I missed that one.
Okay, and I've got the one from the Deputy Minister of Transport as well. Thank you very much. Colleagues, then let us, without further ado, continue with the introductions of the department. I think the Department of Transport, if you can just introduce your members on the platform and indicate who will be doing the presentations.
Good morning, Chair, and good morning, the honorable members of the Select Committee. My name is Nzimande, the Deputy Director General, responsible for maritime transport in the department. I've got Mr. Ntuli, Dumisani Ntuli, who is the Chief Director for Policy and Legislation Development within Maritime Branch. He is the one chair that will be leading the presentations. Thank you very much. I'm not sure if I've missed any member of the team, but I've seen Mr. Ntuli is present. Thank you.
Thank you. If there's anybody else apart from Mr. Ntuli that's present from the Department of Transport.
Good morning, Elizabeth Mche from the Civil Aviation Branch, Department of Transport.
Very welcome, Mr. Chair. Thank you very much. Anyone else? Great, thank you very much. Right, before we go into our presentation, which Mr. Mtuli will take us through, colleagues, can I just mention that once we've done the presentations of the two protocols, we'll then go into deliberations. And then post the deliberations, we will do recommendations on both the protocols, which Mr. Mtulini will flight, and those protocols we will then take up in a report, which we will present to the National Council of Provinces. So the first protocol, if I may just quickly make a few comments, the Montreal Protocol seeks to close the jurisdictional gaps left by the 1963 Tokyo Convention. It's a crucial step in strengthening our international aviation security. As air travel continues to expand, so due to the challenges associated with unruly and disruptive passenger behavior, which then obviously jeopardizes not only the safety of passengers and crew, but also the integrity of global aviation operations. So by ratifying this protocol, South Africa will reinforce its commitment to maintaining good order and discipline on board aircraft and ensuring that those who threaten aviation safety face appropriate legal consequences. So as a committee, our task today is to ensure that protocol aligns with our national interest and legal framework, and I urge all members to engage meaningfully in this discussion so we may advance our collective goal for a safer and more accountable aviation sector. This presentation, and I think Ms. Chair has indicated that she'll be doing the presentation, will be followed by a presentation. I think that will be Mr. Mtuli on the International Convention on Civil Liability for bunker oil pollution damage, which we will also then deliberate on. The protection of our marine environment and today's discussion marks a significant step in ensuring that South Africa aligns itself with international best practices in maritime and environmental protection. The convention was adopted to address a crucial gap in international law, ensuring that ship owners are held accountable for pollution damage caused by bunker oil spills. While South Africa is already a party to the International Convention on Civil Liability for Oil Pollution Damage, it does not cover the spills originating from fuel used to power ships. This has left communities and government agencies to bear the burden of costly cleanups, with often limited recourse for compensation. So by ratifying this convention, South Africa will strengthen its ability to hold polluters accountable, provide certainty for compensation claims, and obviously ensure that those responsible for marine pollution bear the financial cost for remediation. This is a necessary step towards protecting our natural resources, marine biodiversity, and the livelihoods of all that depend on them. So as I alluded to earlier, colleagues, after the conclusion of our two deliberations, we will then move for the two international agreement reports to be tabled for adoption by the NCOP. I can then hand over to the department. I believe Mr. Chair from the Department of Transport, you will be the first to present the Convention on Offences, Certain Other Acts Committed on Board Aircraft. Thank you very much.
Thank you, Chair. I don't know if I'm expected, am I expected to share the presentation from my end, or it will be shared from your side, Chairperson?
Mr. Mtulini, can you share the presentation?
Chairperson, it's better for the department to share on their part.
Okay.
We've given them hosting rights.
That's fine. Then let the department, Ms. Chair, if you can do it from your side.
Noted, Chair. Apologies, Chair. I'm trying to retrieve the presentation. My sincere apologies.
I've saved us 2 minutes so far, so you've got 2 minutes.
Thank you.
I'm just going to put my camera off to save bandwidth on my side. I will then wait for you to flash your presentation. Thank you.
Thank you, Chair.
Just in case, Mr. Mtuli, are you ready with the second presentation? Okay, there we go. Right, we can see it. If you can just put it into presentation mode, there we go. It's perfect. Thank you. Please continue.
Thank you, Chairperson. In terms of the reason which you have articulated, we are here to present the ratification of the protocol to amend the Convention on Offences and certain other acts committed on board aircraft. And the reason why we are appearing before the Select Committee today is to request the committee to consider the protocol to amend the Convention on Offences and certain other acts committed on board aircraft for approval by the House in terms of Section 2312 of the Constitution. And as an introduction, the Convention on Offences and certain other acts committed on board aircraft, which we often refer to as the Tokyo Convention, was negotiated under ICAO, which is a UN specialized agency that is responsible for civil aviation issues, and was adopted at Tokyo on 14 September 1963, and it entered into force on 4 December 1969. And South Africa, as a member state of ICAO, South Africa ratified the Tokyo Convention on 26 May 1972. In the process of implementing the Tokyo Convention, it was then discovered that there were various weaknesses and loopholes that allowed unruly passengers to escape prosecution, and mainly because of jurisdictional issues. So to address the loopholes that were identified in the convention, the parties, different member states, ICAO member states then met in Tokyo, met in Montreal in 2014, and they adopted a protocol, the protocol to amend the Tokyo Convention, and this protocol was then named Montreal Protocol. So South Africa signed the protocol on 25th of September 2019, and we signed this during the assembly. And the Montreal Protocol entered into force on 1st January 2022 because it was ratified by 22 member states. So air travel is considered to be the most and the safest mode of transport. But however, we are experiencing challenges with unruly passengers, and this unruly and disruptive behavior of minority passengers has an adverse impact on the safety of other passengers and cabin crew on board the aircraft. And the problem is that a significant number of unruly passengers who commit these offenses on board aircraft rarely faces prosecution and penalty, and mainly because the convention gave jurisdiction over offenses committed on board aircraft to the state of registration of the aircraft in question. So the jurisdiction here, Chair, was only in the Tokyo Convention. The jurisdiction is only limited to an aircraft, a state of registration, a state where the aircraft is registered at. It excludes the state where the aircraft lands, and also the state where the particular aircraft operates at or operates into. And this causes problems because when then that particular aircraft lands in a foreign country, there's an issue then because law enforcement do not have jurisdiction because the aircraft in question is registered in another state. And in such a scenario, an unruly passengers are released to continue their journey without being prosecuted or without any sanctions being imposed on them for their misbehavior on board aircraft. And the International Air Transport Association confirmed that the jurisdictional gap is the main cause for lack of prosecution globally. So this is not a problem that is only encountered by South Africa, but this is a problem that is encountered globally. And the objective, therefore, of the protocol, Chair, the Montreal Protocol aims to extend the jurisdiction over offences and act committed on board aircraft to the state of landing, and secondly, to the state of operator. The protocol seeks to close the jurisdictional gap that has been created by the Tokyo Convention and to assist in curbing unruly behavior on board aircraft. And this will ensure that unruly passengers do not escape prosecution because of lack of jurisdiction. And by us ratifying, I mean South Africa, there are actually benefits. And South Africa, by ratifying the protocol, we will then derive the following benefits. The first one will be the jurisdiction as a state of landing, because we have a number of foreign aircraft that lands in our territory. So the jurisdiction as a state of landing or as a state of operation to initiate criminal, administrative, or other form of legal prosecution. We will therefore, when aircraft lands into our country or they operate in the country, our law enforcers will then have jurisdiction in terms of giving administrative or other form of legal procedures to any passenger that committed or any offense on board the aircraft. Secondly, recognition that aircraft have a right to seek recourse for costs caused by unruly passenger incidents, because normally you'll find that there's an unruly passenger on board, and because of their unruly behavior, the aircraft end up being delayed, and obviously there are costs incurred in that scenario. So this will then assist us that our operators will therefore then have a recourse for them to then claim any costs associated with unruly passenger incidences. And the other benefit is that the protection of aircraft, persons. So the next section then summarizes what is contained in the protocol itself. So the protocol starts with a preamble, and in the preamble, we are noting the states have expressed their concern about the escalation and severity and frequency of unruly behavior on board aircraft, and this might jeopardize the safety of the aircraft or of the persons or properties therein, or jeopardize good order or discipline on board the aircraft. The protocol is recognizing the desire of many states to assist each other in curbing unruly behavior and restoring good order and discipline on board aircraft. And also the state believes that in order to address these concerns, it is therefore necessary to adopt provisions to amend those of the Tokyo Convention. And in terms of the articles contained in the protocol, Chair, Article 1, it amends the Convention on Offences and certain other acts committed on board aircraft that was signed at Tokyo in 1963. And Article 2, it then replaces Article 1. It actually replaces paragraph 2 of Article 1 of the Convention. to provide that an aircraft is considered to be in flight at any time from the moment when all its external doors are closed following embarkation until the moment when such doors are open for disembarking. And Article 3, it replaces Article 2 of the Tokyo Convention, and it provides that no provision of the convention shall be interpreted as authorizing any action in respect of offences against penal laws of a political nature or those based on discrimination on any ground such as race, religion, nationality, ethnic origin, political opinion, or gender. Article 4 then replaces Article 3 of the Tokyo Convention to provide that state of registration of the aircraft is competent to exercise jurisdiction over offences and act committed on board. The protocol, as I indicated earlier, this protocol now extends the competence to state of landing and state of operator. Then Article 5, Chair, it provides that a contracting party must consult with other contracting parties with a view of coordinating an investigation, prosecution, or judicial proceedings with respect to offences committed on board. And Article 6, it deletes paragraph 2 of Article 5 in the Tokyo Convention. And Article 7, it replaces Article 6 of the convention, and it provides that an aircraft commander may impose upon a person such reasonable measures, including restraint, when he has reasonable grounds to believe that such a person has committed or is about to commit on board an aircraft an offense. Article 8 replaces Article 9 in the convention to provide that an aircraft commander may deliver to the competent authority of any contracting state of which the aircraft lands any person he has reasonable ground to believe that that person has committed an offense on board the aircraft. And Article 9, Chair, replaces Article 10 of the Tokyo Convention, and it provides that neither the aircraft commander or any member of the crew, any passenger, any in-flight security officer, or the owner of the aircraft shall be held liable in any proceeding on account of the treatment undergone by the person against whom the actions were taken. And Article 10 provides that each contracting state is encouraged to take such measures as may be necessary to initiate appropriate criminal, administrative, or any other form of legal proceedings against any person who commits on board an aircraft an offense. And Article 11, Chair, replaces paragraph 1 of Article 16 of the Tokyo Convention, and it provides that offences committed on board aircraft shall be treated for purposes of extradition between contracting parties, as if they had been committed not only in the place which they occurred, but also in the territories of the contracting states. And Article 12, Chair, replaces Article 17 of the Tokyo Convention, and it provides that in taking any measures for investigation or arrest in connection with an offense committed on board an aircraft, the contracting state shall pay due regard to the safety and other interests of air navigation and shall so act to avoid unnecessary delay of aircraft, passengers, crew, or cargo. Article 13, Chair, amends Article 18 of the Tokyo Convention, and it provides that nothing in the conventions shall preclude any right to seek the recovery under national law of or damage incurred from a person disembarked. And Chair, Article 15, Articles 14 to Article 15 are mainly administrative processes. And in terms of the stakeholders that we consulted with our safety regulator, the South African Civil Aviation Authority. We consulted Airline Association of Southern Africa. We also consulted our national airline. We We consulted also the Department of Justice and Constitutional Development. We consulted the Department of International Relations and Cooperation, consulted Presidency, and we also went through the cabinet cluster committees and their subcommittees. We also consulted, presented to PCOT, and it was also presented to the National Assembly, and we received approval, hence we are here today. So in terms of the decision required from the committee chair, we are recommending that the committee approves the ratification of the Montreal Protocol. I submit, Chairperson.
Thank you very much, Mr. Chair. That's a very clear and very concise presentation, and I think it's very well done. Thank you for your time management. I really appreciate that. I can see DDG Dia is ready to present Mr. Mtuli as the presenter of the next presentation. Colleagues, I think we'll do both presentations and then allow some time for deliberations. DDG Mandia, over to you, please.
Thank you, Chair. As I indicated earlier on, I will request Mr. Ntuli to take the committee through the presentation. Thank you very much.
Ntuli, please continue. You might be muted. I think, Mr. Mtuli, just check, you might be muted. I don't get any sound from you. Colleagues, is it just me, or can nobody else hear as well?
Yes, Chair, we can't hear anything.
Okay. Sorry, Mr. Mtuli, I think you might have an issue with your microphone. DDG, do you want to, in the meanwhile, take us through the presentation?
Yes, Chair. I think to manage time, Mr. Ntuli will just indicate when is able to talk. I will take the committee through the presentation.
Thank you. Please proceed.
Can the presentation be flight back again?
MTN will send.
I do not have, Chair, the presentation on my end. I take it was oh, no, there's Mr. Ntuli waiting to be admitted. I think the issue was the
Ntulini, I think maybe if you can resubmit Mr. Ntuli.
Chairperson, I've already readmitted.
Okay,
Can you hear me now?
Yeah, we can hear you. Thank you very
Oh,
much.
no, that's fine. Okay, thank you. So, sorry for that hiccup. Let me just then quickly share the presentation.
It's okay. We're going to take 2 minutes off your time now. So you've got 13 minutes instead of 15 minutes.
Thank you so much. Is the presentation up now?
Yes, the presentation is up. You can just maybe put it into presenter's view.
Presentation mode, yes.
That's it. Got it. Thank you.
Yes. Our sincere apologies here, Chair, and this was, I think, the technology make its presence known. But I will just move very quickly with the presentation. This slide, members would be familiar with it because it just shows where we are with the process of ensuring that the Republic has got a marine pollution prevention strategy that is effective. You'll notice that the Bankers Convention right on the right of the screen is reflected in amber, which shows that it hasn't been accomplished, but all the other boxes in green. And the Bankers Convention is entering this phase, therefore, with the hope that we would be able to, working together to ensure that it is turned to be green. The purpose of the presentation, Chair, then is to request a select committee to consider this convention on civil liability for bunker pollution, which was adopted in 2001 for adoption in terms of Section 231 of the Constitution. This convention was adopted by IMO to ensure that adequate, prompt, and effective compensation is available to persons who suffer damage caused by spills of oil when carried as fuel for ships, because ships carry fuel in two forms. One is carried fuel as cargo, and it carries fuel for use, for consumption by the ship. The convention applies to damage, therefore, caused on the territory, including the territorial sea and exclusive economic zones of state parties. The convention met the criteria for entry into force in 2007 and came into force internationally on 18 November 2008. The reasons why it is of importance as America ratifies this convention, accedes to it, is that it applies a strict liability for pollution from oil tankers, which is established by this convention. Because you recall that we currently have the CLC, which is the International Convention on Civil Liability for Oil Pollution Damage, which does not cover fuel used by ships for consumption. So this convention, which is then in short called the Bankers Convention, is to close that gap. The status quo makes it difficult and costly for affected parties, including South Africa, to file claims and create uncertainty regarding the ability to be compensated for clean-up costs of economic loss in the event that the bunkers spill. Affected parties, including South Africa, may not also receive compensation, and clean-up costs may fall on the central and local government agencies that have carried out the clean-up on operation, which would put a strain on the national fiscus. Now, the convention itself in its preamble recalls the United Nations Law of the Sea Convention, which is the principal convention governing the oceans. It also recalls Article 235 of the convention, which provides that the objectives of assuring prompt and adequate compensation in respect of all damage by pollution on the marine environment. It also notes success of the 1992 Convention on Civil Liability for Oil Pollution Damage and the establishment of the Fund Convention in 1992, and that compensation is now available to cover those types of damages caused by the spills. Also notes the adoption of the International Convention on the Liability and Compensation for Damage in connection with the carriage of hazardous, noxious substances by sea in 1996 in order to provide adequate, prompt, and effective compensation for the damage caused by the carriage of hazardous and noxious substances. It recognizes the importance of establishing strict liability, as I've indicated earlier on. It also considers that complementary measures are necessary to ensure the payment of adequate, prompt, and effective compensation for damage caused by pollution resulting from the escape of discharge of bunker oil from ships. It desires, therefore, to also adopt uniform international rules and procedures for determining questions of liability and providing adequate compensation in such cases. I'll then just touch on the key definitions which are important for the committee to note. What is bunker oil? It means any hydrocarbon mineral oil, including lubricating oil, used on or intended to be used for operation or propulsion of the ship, and any residual of such oil. Preventive measures means reasonable measures taken by persons after an incident. The incident itself means any occurrence or series of occurrences having the same origin which causes pollution damage or grave and imminent threat of causing such damage. Pollution damage means a loss of damage caused outside the ship by the contamination resulting from escape or discharge of bunker oil from ship, wherever such escape or discharge may occur. It also provides compensation for impairment of the environment other than loss of profit from such impairment shall be limited to a cost of reasonable measures of reinstatement actually undertaken or to be undertaken, and the cost of preventive measures and further loss or damage caused by the preventive. So you can see that the net in terms of coverage is very wide. The convention itself then would exclusively apply to pollution damage caused in territory, including the territorial sea of a state party, and in the exclusive economic zone of state party established in accordance with the international law, or if a state party has not established such a zone in an area beyond and adjacent to the territorial sea of the state by that state in accordance with the international law, and extending not more than 200 nautical miles from the baseline from which the breadth of the territorial sea is measured. So you notice here that this is an UNCLOS language that's being used in terms of ensuring that the coverage is very clear. Article 3 provides exceptions as provided in paragraph 3 and 4. The ship owner at the time of an incident shall be liable for pollution damage caused by any bunker oil or on board or originating from the ship, provided that if an incident consists of series of occurrences having the same origin, the liability shall attach to the ship owner at the time of the first of such occurrences. Article 3, continuing, it also covers the damage resulting from an act of war, which is excluded, the damage which was wholly caused by an act of omission done with the intent to cause damage by a third party, or the damage was wholly caused by the negligence of other wrongful act of any government or other authority responsible for the maintenance of flights and other navigational aids in the exercise of that function. This convention shall not apply to pollution damage defined by the Civil Liability Convention, whether or not compensation is payable in respect of it under that convention. 2, except as provided in paragraph 3, the provision of this convention shall not apply to warships, naval auxiliary and other ship owned or operated by state and used for the time being only on government non-commercial service. Said party may decide to apply this convention to warships or other ships described in paragraph 2. So that's left to the discretion of the state. With respect to ships owned by state party and used for commercial purposes, each state shall be subject to suit in the jurisdiction set forth in Article 9 and shall waive all defenses based on its status as a sovereign state. Article 5 provides for incidents involving 2 or more ships, and it provides as follows: that when an incident occurring in 2 or more ships occurs and pollution damage results thereof, the ship owner of all the ships concerned, unless exonerated under Article 3, shall be jointly and severally liable for all such damage which is not reasonably separable. The registered owner of a ship, in terms of limitation, having a gross tonnage greater than 1,000 tons registered in a state party, shall be required to maintain insurance or other financial security, such as the guarantee of a bank or a similar financial institution, to cover the liability of the registered owner for pollution damage in an amount equal to the limits of liability under the applicable national or international limitation regime. So this is important because that contribution goes into the international insurance for compensation purposes. A certificate attesting that insurance or other financial security is in force in accordance with the provisions of this convention shall be issued to each ship after the appropriate authority of a state party has determined that the requirements of paragraph 1 have been complied with. A state party shall not permit a ship under its flag to which this article applies to operate at any time unless a certificate has been issued under paragraph 2. So you can already see that a ship will not be allowed to sail unless it has this international certificate confirming the contribution to the insurance. The substitute provision of this article, each state party shall ensure that under its laws that insurance or other security to the extent specified in 1 is in force in respect of any ship having a gross tonnage greater than 1,000. Notwithstanding the provision of paragraph 5, a state party may notify Secretary General of the IMO for the purposes of paragraph 12. Ships are not required to carry on board or to produce certificates required by Article 2 when entering or leaving a port or arriving at or leaving from offshore facilities in its territory. In terms of the time limit for claims, Article 8 provides that rights to compensation under this convention shall extinguish unless an action is brought thereunder within 3 years from the date when the damage occurred. However, in no case shall an action brought more than 6 years from the date of the incident which caused the damage, where the incident consists of series of occurrences, the 6 years period shall remain from the date of the first such occurrence. In terms of jurisdiction, Article 9 provides that when incident has caused pollution damage in the territory, including territorial sea or any area referred to into a of one or more states. Now, this cross-boundary or preventive measures have been taken to prevent, minimize pollution damage in such territory, including territorial sea or in such area. Actions for compensation against the ship owner, insurer, or other person providing security for ship owner liability may be brought only by the courts of any such state parties, and that a reasonable notice be given as each state shall ensure that its courts have jurisdiction to entertain action for compensation under this convention. We will do that when we then domesticate the treaty. In terms of recognition and enforcement, Article 10 provides for that any judgment given by a court with jurisdiction in accordance with Article 9, which is enforceable in the state of origin, where it is which is longer subject to ordinary forms of review, shall be recognized in any state party, except where the judgment was obtained by fraud, where the defendant was not given reasonable notice and a fair opportunity to present his or her case. So this is important in terms of ensuring that cooperation globally, that the enforcement is ensured, and that a judgment recognized under paragraph shall be enforceable in each state party. So any party, South Africa will be obliged, therefore, to enforce any enforceable action required on ships that come South Africa's shores. In terms of consultation, these are the list of the departments that we've consulted. State law advisors were both domestic, Department of Justice, as well as international relations were consulted. And the convention was also consulted with the following departments: National Treasury, Department of Mineral Resources, Southern Petroleum Industry Association, Maritime Law Association, local government authorities, and it was also presented to PCOT, and it was adopted in its report of 1st March 2022. We are humbly requesting that the Senate Committee on Public Infrastructure and Minister and the President to consider this convention for adoption by the House in terms of 2312 of the Constitution. I thank you for your attention, Chairperson. I hand over to DDG Madia.
Thank you, Mr. Ntuli. Thank you, Chair, for the opportunity. I think some of the questions, Chair, if you'll recall from our submission last week, they touched on the readiness and of South Africa in terms of dealing with oil spillages. I think we had a lengthy discussion. I'm sure this presentation tries to address some of the issues that were raised by the Honorable members when we presented last week. I'll hand over back to you, Chair. Thank you very much.
Very much, DDG Madea, and thank you so much, Mr. Ntuli, for the presentation. Once again, a lot of information was reduced into a very concise presentation for the committee. We very much appreciate that. Honourable members, let us go over to deliberations. Can we have a show of hands? I will allow for 2 minutes per member. And I would like the department to answer every time directly after a member has asked a question. So just for the sake of clarity, when you ask your question, just indicate whether it's for the flights or for the bunkering protocol. Then we know which department to answer, to get the answer from. So I see the hands of Honourable Skeerkogel. I see the hands of Honourable Nzimande. And I see the hand of Honourable Malakome and Honourable Treza. Great. Let's start with Honourable Skeerkogel. Once you've asked your question, just remove your hand so we can continue to the next hand, please. Thank you very much, Honourable Skeerkogel.
Thank you, Chairperson. My first is going to go about the aviation. So has there been made any assessment been made to the extent of this that incorporates South Africa, the offences and the penalties that were set out in the International Aviation Organization manual on the legal aspects of the unruly and disruptive passengers, which will then go into our national law? The second question, also aviation. It has been said that one of the Tokyo Convention's main flaws is that the convention and now the protocol does not categorize jeopardizing acts and serious crimes. So when the convention is domesticated in South African law, will it then in terms be defined? Then if we go to the maritime law, the bunkers law, in the preamble of the convention, it refers to the successes of establishment of International Fund for Compensation for Air Pollution. So can communities access the fund to form a claim against for the losses that were incurred, or incomes or economic losses for, and future medical expenses? And then the next question is, what's the liability of a ship owner is limited to the instances where it says the damages was wholly caused by negligence or other wrongful acts of any government or any other authority responsible for maintaining of lights or other navigational aids and exercise of that fund. So what is the Department of Transport's assessment of the state of South Africa's lights and other navigation aids? My last question is, the convention requires that each state party shall ensure that the courts have jurisdiction to entertain actions and compensation under this convention. So will the amendments be necessary to the Superior Court Act 10 of 2013 when the convention is domesticated in South Africa? Thank you, Chairperson.
Thank you very much, Honourable Skeerkogel. I'll hand over to the department, to Ms. Mche, if you can do the first 2 questions, and then I'll hand over to the Department of Transport for the second 2 questions. Thank you very much.
Thank you, Chair. It was very difficult to hear the question, but I'll try. Honestly, we were struggling from our end. And I think the question was around national law and domestication. And currently, we have the Civil Aviation Act. And in the Civil Aviation Act, because what we have in the Civil Aviation Act is what is in the Tokyo Convention. And the Tokyo Convention is only limited to state of registration. So once we ratify the Montreal Convention, we will then be able to go back and amend the Civil Aviation Act and include the state of landing and the state of operation. So I'm not sure if I've covered the question that was posed, because I could only hear national law and domestication.
Honorable Skeerkogel, are you covered by that?
Better to now I'm clear. Now, my question has just been, has an assessment made to what extent the South African will incorporate the offences and penalties set out by the Aviation Organization on legal aspects of unruly and disruptive passengers into national law? So that was the one question. And then also, the protocol doesn't categorize as what is jeopardizing acts and serious crimes. So when the conviction is domesticated, will it then be defined? I heard what she said, but those two are the two things. Is that incorporated? So that maybe I'm clearer now, Chair, because I took down my earphones.
Thank you very much, Mr. Chair. I think that was a little bit clearer. Is there anything else you want to add?
No, thank you, Chair. I think of the national law, we've outlined that it will be incorporated. We'll have to amend the Civil Aviation Act, and we'll then have to incorporate it into the Civil Aviation Act. In terms of the offences, they are actually clearly articulated in the manual. We have a manual that actually is part of the Montreal Protocol, and the manual clearly outline, if we talk about assault or other acts, it clearly then defines them, drills them down, defines them in terms of what are we referring to. Like when we are talking about assault and other acts endangering safety or jeopardizing good order and discipline, we are talking about assault, intimidation, threat, physical or verbal. So they are clearly categorized in the manual on the legal aspect of unruly and disruptive passenger. Thank you, Chair.
Very much. I think are you covered by that, Honorable Skeerkogel?
Yes, I am, Chair, on that. Thank you.
Thank you very much. Then over to the questions you asked regarding the bunkering.
Yes, no, thank you very much, Chair, and thank you for the questions that were raised. Am I audible?
You are. Thank you. Please continue.
Thank you very much. Yeah. Okay, so the question related to whether communities can claim in terms of the 2013 Act, which is the Civil Liability, which is the Merchant Shipping Act for civil liability compensation. So yes, because South Africa is party to the CLC, and as well as it has this Act 25 of 2013, all claims that have been assessed by the International Oil Pollution Compensation Fund Secretariat are claimable and payable by that fund. So the assessment will determine as to whether the incident involved a ship that is covered by the convention, by the CLC convention. Now, then the other question related to the state of aids to navigation along the coast of South Africa. I need to, in response to that question, just to let the members have assurance that South Africa keeps its aids to navigation in line with the standards set by the International AIDS to Navigation Organization, which prescribes exactly the standard that must be kept, and the National Ports Authority keeps such. But also SAMSA as a safety authority, it in terms of the relevant provisions of SOLAS ensures that the aids to navigation provided by the Ports Authority are in line with the provisions of SOLAS. So that's the response to those two questions. Thank you very much.
Thank you, DDG. Honorable Skeerkogel, are you covered by those?
Thank you, Chairperson. Now, just the other question was, when it's domesticated, will it be necessary to amend the Court Act of 10 of 2023? That was just not answered.
Yes, also in terms of that question, yes, once we have ratified this treaty, then we would then look at various options to domesticate it. Yes, we would consider the possibility of amending Act 25 of 2013 to incorporate the damage by bunker oil used by ships. Thank you.
Are you covered, Honourable Skekogel?
Thank you, Chair.
Great. Thank you very much, Honourable Nzimande. Thank you for waiting patiently. It's your turn.
No, thanks, Chair. Mine are a few. I'll start with the aviation. The question that one wants to ask is in relation to the unruly element. Who becomes, has the thinking gone to an extent, who becomes a complainant between the passenger and those that are responsible for the flight? And secondly, in the event of the unruly element was directed to a passenger and the passenger is not willing to even cooperate or engage on that, has the thinking gone to an extent to say this ought to happen? Or has the thinking also gone to an extent who incur the cost if there is a cooperation from a passenger to come and assist in relation to the prosecution of the individual? But again, the last part, it relates to the signage. Obviously, one country to another differs in terms of the scheduling of the criminal offences. Has that also been applied in terms of thinking? The last two then deals with the bunker. Actually, it's something, a statement that comes from Article 3. There is a qualification on liability. Can we be clarified on that ship owner liability qualification, that it be subjected to series? And if it's not one, then what happened? If it's not series, then what happened? The last one is in Article 5, the joint liability. What if in case, obviously, the other that is involving in that situation is not at fault? Why joint liability? Because the fault must always be liable. Be extended only to a person who is at fault. The fault must be put on the shoulder of the one that has caused it. Thank you.
Thank you, Monday. Thank you for your time management. It's much appreciated. Mr. Chair, the first three questions for you, and then we'll hand over to the Department of Transport again to Mr. Mdia. Thank you very much.
Thank you, Chair. In terms of in terms of who becomes a complainant between the passenger, so in an aircraft and these incidences, they were mainly in our country. They were mainly reported in SAF air flights. So what normally happens on board aircraft, if there's an unruly passenger, some passengers, if the aircrew is not aware of the incident, then the passengers will then report or will then alert the crew member of the incident or of the incident, the unruly behavior. And what normally happens then, the air crew is the person then who will be responsible for recording the incident, is the person who will then be responsible for handing over the unruly person when they land in a city or a country, wherever they will be landing in. So the aircrew will then hand over the passenger with the incident report that the aircrew member will have, the crew member will have registered on board the aircraft. And the criminal jurisdiction, so the Montreal Protocol does not exclude any criminal jurisdiction exercised in accordance with national law. So it therefore means that wherever, hence we want to add the state of landing and the state of operation. So wherever the aircraft lands, the national law of that country will be applicable. I think I've answered, unless if there's a question that I missed.
Thank you. Honorable Mzimande, are you covered by those first three questions?
No, Chair, the first one that she attempted to respond to, the issue of processing the information, is different from prosecution. I was just asking at a level of prosecution, who becomes a complainant? And should it be is it a passenger, or who would be the actual complainant? If it's a passenger, who incurs the cost of that passenger to go and assist in terms of testimony? That's one element. Then the other one, obviously, I guess she has answered it, but the inconsistency that you'll find in one country to another in terms of the classification of the criminal act, I saying the law of that country will deal with that. Thank you.
Okay, got you. Thank you very much. Ms. Mshe, I think it's clear. If a passenger is the complainant because the act was against one of the other passengers, what happens with the prosecution of the case? Does the cost of that passenger having to testify in the subsequent legal proceedings, what is the arrangements regarding that?
Oh, thank you, Chair. So for aviation, our role is to process the information and hand over the information to the law enforcement agencies or the law enforcers. And that's where our role ends. And in terms of then getting witnesses, covering the cost of witnesses, that is a process that is now then taken care of by the law enforcers. The cost that we seek to recourse, it's mainly the costs that are incurred by the airlines should they experience a delay or should they experience any damages to the aircraft because of the unruly behavior. But in terms of prosecution and getting witnesses to physically appear before the court, that is the responsibility of law enforcement. We don't get involved there.
Thank you very much. The Department of Transport, on the bunkering side, there's, I think, two questions from Honorable Nzimande.
Yes, Honorable Chair, and thank you very much for the questions from Honorable Nzimande. To respond to that question, if you read Article 3 carefully, in the presentation, it shows that a ship owner at the time of an incident shall be liable for pollution damage caused by any bunker, oil on board, or originating from the ship, provided that if an incident consists of series. So where the convention refers to a series of occurrences, it means that there would be more than one vessel involved. And because oil moves very fast on water, these occurrences, they mix together. So it is always difficult to ascertain and apportion appropriately the level and the extent of the damage of the spill originating from any of the vessels involved, maybe 2 vessels, maybe three vessels. So then it says the same, so the liability shall attach to the ship owner at the time of the first of such occurrences. So if it to be that ship, and including the ship. So if you go to Article 5, then where there is exoneration in terms of liability, and those are the conditions that are indicated where there is a war and where there is intentional or an act of omission to cause damage by a third party, which is not the ship in this case, or a damage was wholly caused by negligence or other wrongful doing of the government. And I think where the aids to navigation, maybe the traffic separation scheme was not clear for vessels to navigate, and somehow there was a collision, then it becomes a problem. But where then, now going to Article 5, when an incident involving 2 or more ships occurs and pollution damage results therefrom, the ship owners of all the ships concerned, irrespective of the size or the extent of the damage, unless exonerated under Article 3. Now, Article 3, remember, where there was a war or there was negligence because of the aids to navigation, they shall be jointly and severally liable for all such damage which is not reasonably separable. So I just hope that Honorable Nzimande is able to link these clauses sequentially so that it is clear, and also the challenges of not being able to separate this damage that has caused the spill. Thank you.
Thank you very much, Mr. Ntuli. I don't see Honorable Nzimande's hand, so I assume that he's covered by your answer. Thank you very much. Honorable Molokome. Thank you, Honorable Nzimande. Thank you. Honorable Molokome.
No, thank you, Chairperson. I think my questions, or maybe let me just start by
Honorable Molokome,
appreciating the
I'm
two
sorry.
presentations made in
Honorable
the meeting.
Molokome, I'm sorry for interrupting you.
Am I not audible?
Yeah, maybe just take your video down. I think it might make you, there we go. I think it might make you more audible. Thank you. Please continue.
Okay, thanks, Chair. I was saying, let me start by appreciating the presentation, the two presentations made by the department, and also to indicate, Chair, that the questions that I wanted to ask was covered. I don't want to waste time because I wanted to check on the very same issues that Honorable Kirkohan has asked on in terms of the offences. And on the second presentation, I wanted to check in terms of the occurrences. So the two questions that I had is covered. But Chair, I want to register a bit of a complaint in terms of when we are, these departments, when we are going to our own provinces to deal with the issues of presenting the bills, you'll find that you are struggling to get the officials from the departments. So I had to go there last week in Limpopo. So I just want to register this to department that when we go to the provinces, just make sure that your officials are ready to go and present with us. So I've struggled, Chair. So, and I don't think this must repeat itself in our next presentations in the various provinces. But I'm covered. My questions are covered. Thanks, Chair.
Thank you, Honorable Molokome. I'm sure that DDG Madia has taken note of your comment regarding the attendance at, I'm assuming that's the public participation process of the marine oil pollution bill. So I think DDG will take note of that. But thank you for your comments. It's much appreciated. Honorable Cesar.
No, thank you very much, Chair. I have 2 pointed questions, and they relate to the aviation to aviation. I just wanted to ask in terms of the protection of unruly passengers, whether there is a role of Interpol. What is the role of Interpol in events where there is a handover? And secondly, under that question, do you consider that in an event where you hand over an unruly behavior abroad from South Africa, do you consider our constitutional rights as citizens vis-a-vis draconian laws elsewhere, and whether there is intelligence work to preempt such unruly behaviors in flights? The second one, Chair, pertains to the Convention on Civil Liability on Bunker Oil Pollution. I just wanted to record that transport is very, very essential to ensuring the efficient movement of people, goods, and the economic activities. And therefore, it's very, very important to look at the insurance of people that are affected. What is the limit of liability for property claims for ships not exceeding 2,000 gross tonnage? Is it calculated in rands or US dollars, and how so? Thank you very much.
Thank you very much, Honourable Pleza. Mr. Chair, I think there's one question for you, and then Mr. Mtuli through DDG, I think there's one question for you as well. Thank you.
Thank you, Chair. So the Interpol in this case, they don't play a role, because here we're not talking about hardcore criminals who commit theft, fraud, money laundering, or corruption. Here we are talking about an ordinary passenger. It's Elizabeth flying to a certain destination, and in there you commit offenses like I smoke in the lavatory, I tamper with the smoke detector. So those are offenses that I'm committing in a flight, or I either assault a fellow passenger while I'm on board the aircraft. So Interpol does not get involved. The people that get involved are the law enforcers, where the aircraft will either be landing or where the aircraft will actually be operating. And in terms of administering the penalty or the legal proceedings, the officials there that have to look into the offenses are your aviation security officers, are your police officers, or any other person that is actually considered to fall within the law enforcement agencies in that country that actually deals with issues relating to transportation of passengers by air. So Interpol in this case does not actually get involved. And in terms of the national laws that apply, if you commit an offense on board an aircraft, you are going to Singapore and the aircraft lands in Singapore, the national laws of Singapore will apply. The constitutional right of South Africa will only become applicable and relevant if that aircraft lands in South Africa and we have to prosecute a passenger that is on board an aircraft that landed in South Africa. I submit, Chair.
Thank you very much. Are you covered by that, Honourable Pleza? We will go to the bunkering question.
Chair, I just wanted one follow-up. So,
sure.
Ma'am, you are not speaking to the issues of terrorism that could possibly happen in a plane, and of handing over people to draconian laws elsewhere, whereas South Africa does put corrective measures for offenders of assault and categorize the amount, if you like, the intensity of the offense that you have actually committed. Isn't that quite interesting to you?
Sorry, Mr. Chair, is that clear?
Thank you, Chair. So this act does not deal with terrorism on board an aircraft. This deals with offences, the ones that have been articulating that are committed on board. We have a convention, other conventions like the Beijing Convention, for example. It will talk about unlawful interference, and those are where the terrorism elements are covered in. But this specific one does not cover elements of terrorism. Thank you, Chair.
Thank you very much.
Maybe if Chair can allow, just to augment Acting DDG's response, I think the offences, Chair, are graded according to what the passenger is being accused of. So any unwarranted behavior on board the vessel will be treated as such. And it does not also mean the passenger is guilty. The process of the landing of the aeroplane's country will then be assessing the issue based on what has been submitted by the captain or the crew of the vessel or of the aircraft vis-a-vis what the passenger will be submitting as a mitigation of the perceived or alleged behavior. So it does not mean the passenger is guilty by virtue of being reported to the local authority, but there should be a fair process to ascertain whether the passenger is wrong or the complainant in the form of the captain or the crew has alleged. Thank you, Chair.
Thank you very much. Is that the second question I think Honorable Fraser asked to the regards bunkering? I think with regards to the
Yes.
currency that has been charged.
Yes. No, thank you very much, Chair. Just to draw the attention of the members that these matters that have been raised by Honorable Fraser are covered in the second, please to open this one. They are covered in the Act of 25 of 2001, Merchant Shipping Civil Liability Convention Act, which was signed by the President in 2013. So in terms of the compensation, the depending on the claims, if for instance the claim relates to an action of a ship, so there are limits that are provided for, which are payable in local currency, in rands. But in cases where the damage and the claim relates to the damage caused by the ship itself, those claims are determined in terms of the special drawing rights, which is equivalent to US dollars, but that all that is determined by the IOPC funds to which South Africa is a party to. So two things: if it's a ship and the ship has been found to have contravened the pollution prevention legislation, the courts determine the the fines in terms of the rand value, and if it's the claims caused by the ship and claimable at the International Oil Pollution Compensation Fund, the special drawing rights equivalent to US dollars are used in determining the currency that must be that the compensation must be based upon. Thank you very much.
Honourable Keza, I see your hand is still up, and your hand, Honourable Malakome, is it legacy hands?
It's a legacy hand, Chair. Thank you.
Thank you very much. Thank you. If I might just thank you so much for the department for the answers and the engagement from the members. If I may, just a quick question. I'm aware that we're running out of time. To the department regarding the bunkering, Department of Transport. Last week when we had the interaction with the Biodiversity Law Centre, I think one of the questions that came up was regarding why South Africa allows offshore ship-to-ship bunkering, where the international best practice is that this is only allowed during an emergency when fueling vessels can't, for some other reason, transfer the fuel on port side. So if the department could maybe just respond or indicate why South Africa actually allows this practice of offshore ship-to-ship bunkering when it's not international best practice. Thank you very much.
Thank you, Chair. Maybe I can try to respond to that question, Chair, and the members. The ship-to-ship bunkering is an internationally accepted form of refueling the vessels. It happens all over the world. It's within the frameworks of the IMO. It only differs on the mitigations, interventions that should be taken into consideration to make sure that the operation is safe. From the point of having sufficient insurances, from the point of making sure that the domestic laws of that particular country in terms of pollution preventions are well coordinated, to make sure that you've got sufficient resources, physical and otherwise, to make sure that should any spillage takes place, there are contingency measures in place from that particular country to make sure that you circumvent the damages that may occur on an environment. So the ship-to-ship, in terms of economical benefits, is massive in alleviating poverty and also creating economic opportunities for that particular region or the country. It is, Chair, a well-accepted international best form of economic activities to allow ship-to-ship. Just in closing, Chair, if you look at the value chains and the benefits that comes out of that operation, from the crew change, that increases the movement of passengers that are finishing or starting their shift from that particular country, the food that is required by the crew, and there's a lot of benefit that emanates from there, but it should not be in the detrimental of the environment of the country. Hence, you have to make sure that you've got environmental protection initiatives that are in place to make sure that that operation takes place within those confinements. Thank you, Chair.
Thank you very much, DDG. Thank you for that response. I'm going to ask Mr. Ntelini if we can go across to the next part of our agenda. We are now going to present the brief reports on both of these protocols. I think we'll do the one on the Convention on Offences and Other Acts on Board Aircraft first, Mr. Ntelini. If we can just flight that report to the members, and I will just quickly articulate the report, and then we'll move for the adoption of that report, and then we'll do the second report after that. Honourable members, so In front of us now on the screen is the report of the Select Committee on Public Infrastructure and Minister in the Presidency on the protocol to amend the Convention on Offences and certain other acts committed on board aircraft dated 26 February 2025. The Select Committee on Public Infrastructure and the Minister in the Presidency, hereby the Select Committee, received a briefing from the Department of Transport on the provisions and objectives of the protocol to amend the Convention on Offences and certain other acts committed on board aircraft, also known as the Montreal Protocol, on the 26th of February 2025. The Montreal Protocol introduces amendments to the Convention on Offences and certain other acts committed on board aircraft. The latter is commonly referred to as the Tokyo Convention. South Africa ratified the Tokyo Convention on the 26th of May 1972 and signed the Montreal Protocol on 25 September 2019. If you can just scroll up a little bit, Mr. Mthalini. Thank you very much. The Montreal Protocol entered into force on the 1st of January 2020, following the ratification by 22 member states. The Montreal Protocol addresses weaknesses and loopholes in the Tokyo Convention that made it possible for unruly passengers on board aircraft to escape prosecution because of jurisdictional limitations. The protocol extends the jurisdiction over the offences and acts committed on board aircraft beyond the state of registration of the aircraft to include the state of landing and the state of the operator. In this manner, the jurisdictional gap created by the Tokyo Convention is closed and will ensure that the unruly passengers do not escape prosecution because of a lack of jurisdiction. Having considered the request for approval by Parliament of the protocol to amend, to scroll up a bit please, the Convention on Offences and certain other acts committed on board aircraft, referred to it, the Select Committee recommends then that the National Council of Province, in terms of Section 2312 of the Constitution of the Republic of South Africa of 1996, approve the said protocol. I would then like to, as has taken place in the National Assembly with our sister committee, the Portfolio Committee on Transport, I'd then like to move this report to be considered as adopted. Can I have a mover, please? Just by show of hands. Thank you, Honourable Skeerkogel. Can I have a seconder, please? Anyone else would like to second? Thank you. Thank you, Honourable Molokome. Sorry, you're not audible, but I assume that you are seconding the report. Thank you very much. Thank you, Honourable Molokome. Honourable members, are there anyone, just by show of hands, that are against the adoption of this report?
Chair, I just want to check as to, because this protocol went through the National Assembly. What was the undertaking of the committee on what you just read, and whether we can get that through our emails on that protocol.
Thank you, Mr. Mthalini. I assume that this report was adopted by the Portfolio Committee. Can you just confirm?
Yes, Chairperson, it was.
Great. If we can then just, as per the request of Honourable Trezor, maybe just get confirmation from that by email post this meeting, please. Can we flight? So the honourable members, thank you. Dr. Clark, I see your hand is up.
Yes, thank you very much, Honourable Chairperson. Chair, I think for record purposes, it's important that Member Molokome be audible when she does second the adoption of the report, or alternatively, even in the chat box, if she could in that way indicate that she seconds the adoption of the report, Chair.
Thank you very much. Honourable Molokome, sorry, you weren't audible when I assumed you were seconding the report. Could you just maybe indicate in the chat box, or maybe try again?
No, I said I second the report.
Thank you. I heard that you are seconding the report. Thank you very much for that. Honourable members, let's move to the second report. We will then take this report as adopted. The second report will be on the International Convention on the Civil Liability for Bunker Oil Pollution Damage, dated the 26th of February 2025. The Select Committee on Public Infrastructure administered the Presidency. The Select Committee received a briefing from the Department of Transport on the provisions and objectives of the International Convention on the Civil Liability for Bunker Oil Pollution Damage. The Convention on 26 February 2025. The International Convention on the Civil Liability for Bunker Oil Pollution Damage, 2001, year in after the Bunker Convention, was adopted by the International Maritime Organization to ensure that adequate, prompt and effective compensation is available to parties who suffer damage caused by oil spills emanating from fuel carried as a ship's bunker. The Bunker Convention came into force internationally on the 18th of November 2008. Strict liability for pollution from oil tankers was established by the International Convention on Civil Liability for Oil Pollution Damage, 1992, also known as the CLC, to which South Africa is a party. The CLC, however, does not cover pollution emanating from fuel to ships' own use, and the Bunker Convention was promulgated to fill this void in the legal framework. Having considered the request for approval by Parliament of the International Convention on the Civil Liability for Bunker Oil Pollution Damage, referred to it, the Select Committee recommends that the National Council of Provinces, in terms of Section 2312 of the Constitution of the Republic of South Africa, 1996, approve the said convention, and I therefore ask this committee to consider this report. Are there a proposer for this report, please? Just by show of hands. Honourable Breed, thank you very much. Seconded. Honourable Skeerkogel, I see your hand is up. Are you seconding it? Yes, thank you very much. Honourable members, are there anybody then by show of hands against this committee adopting this report? Good, I don't see any hands. Thank you very much. This report is then therefore also adopted by this committee. I thank you for your participation. The Department of Transport, Mr. DDG Madia, Mr. Ntuli, Mr. Chair, thank you so much for your participation in this meeting, for the presentations, and thank you very much for attending this meeting. You are very welcome to leave the platform. We are now going on to the second part of this meeting with our engagements of the Department of Public Works and Infrastructure and the IDT. Thank you very much for your presence.
Thank you, Chair, and thanks to the members.
Right, thank you very much. Mr. Ntalini, are we ready for part B of the meeting?
Yes, Chairperson, we are.
Great, thank you very much. I'm going to welcome then, let me just quickly, sorry, I just get my screen ready here. I'd like to welcome Mr. Ntubeni, or let me rather say, I'm not sure who's on the platform. Let me rather hand over to the Department of Public Works and then to the IDT to introduce themselves and to indicate who's on the platform from which department. Thank you very much. Let's start with the Department of Public Works.
Good afternoon, Chairperson and honorable members. My name is Adam Tombele. I'm the DDG responsible for intergovernmental relations, and I'm also entrusted with the coordination of our entities, IDT included. From our side, I'm with the Director for Public Entities, Mr. Mkomashaba. So he's the one who joined me for this engagement. We're having an apology from our DG, who's attending the portfolio committee. The meeting is running as we speak.
I'm in the meeting, Adam. I'm in the meeting. I'm connected. Sorry.
Oh, thank you so much. The DG is in the platform. So he managed to come to this meeting as well. It was his busy day today, having to deal with the portfolio committee on the area of policy and legislation. From the side of entities, Chairperson, we also having our entity IDT. I can introduce them because we work hand in gloves. We have the CEO of IDT, Madam Tibuko Malaka. The one who joined the CEO is the CFO, the Chief Financial Officer of the institution, which is Mr. Londoloza Songwefu. They are also having the head of strategy from the entity, Mr. Christopher Mlauzi. So this is how we are composed, Chairperson, for engagement today. What I want to indicate, Chairperson, I wonder if if you're giving us in terms of sequence of presentation, wanted to start from the side of the department to give an overview on what we need to deal with, and thereafter give to IDT to deal with the issues of annual financial statement. That's how we arrange ourselves, Chairperson. I'll give it back to you. Thank you.
Thank you very much, DDG Mtombeni. I think I will hand over to you. That's fine. We can do the presentation by the Department of Public Works first, and then follow that with the presentation by the IDT. We have until 12:15. So if we can then proceed. If you can just please check for time management, because I'd like the members to ask a few questions if there is time. Thank you very much. Over to you.
Mr. Mashaba, if we can assist on the sharing, just to ease that we have a connectivity problem. If you can assist Mr. Mashaba on the sharing from your side.
Oh, okay.
Yeah.
Okay. Is it showing?
I'll just while we're waiting for your presentation.
Yes, we can see the presentation.
Thank you. I've just just to the committee members, I've just in the interest of saving time, I'm not going to make any comments. We all know the Department of Public Works. They're no strangers to our committee, and also the IDT. They have been to our committee before. Today's meeting is just to look at the annual performance report of the IDT, and then to present and to look at the presentations of the Department of Public Works with regards to IDT solvency, supply chain management processes, and internal financial control issues. We'll then engage and then take it further. Thank you very much. Over to you.
Thank you so much, Chairperson, for this opportunity. We are privileged as a department to come and engage you on this important subject, where as a department we need to give assurance in terms of the IDT solvency, their supply chain management processes, and also internal financial controls. Before I deal with the content of the presentation, Chairperson, is just to indicate that this entity, IDT, we regard it as a going concern from the side of department. We need to support them on their solvency status and liquidity so that they be able to sort of deliver mandate. IDT is one of a critical entity on our side where they're trying to sort of add value in terms of mandates of public works, particularly on the area of delivery of social infrastructure. So, and this particular entity has got a history. It's an entity which was existing for years, where they sort of existed in various forms in order to support the priority of the government of the day. So in the context of 7 administration, this particular entity is also relevant, particularly to help us on the issues of infrastructure delivery. As we are aware, Chair, before I go to the content, in 2019, the Department of Public Works was reconfigured. Initially, we were Department of Public Works, and after 2019, we're called DPWI, Department of Public Works and Infrastructure. The I part, Chairperson, was amplifying and aiding our role in terms of infrastructure delivery. So this particular entity became more relevant to assist us in the area of infrastructure delivery. In terms of content, we'll talk to the purpose. We also reflect on the legislative mandate, and we also put a background in terms of going concern challenges, and also reflect on the financial assistance which we're doing as a department. And we also talk to turnaround initiative to address going concern challenges. We also give highlight in terms of audit outcomes. I'm sure it's a 5-year overview from 2020-21 to 2023-2024. We also put some highlights of IDT performance, particularly Q2, which we assess as a department. Number 8, we deal with the high-level assessment of IDT internal controls, and thereafter we put the recommendations. Next slide. Chairperson, we're here to apprise you on our assessment as a department in terms of IDT solvency, supply chain management processes, and internal finance controls. In terms of legislative mandate, Chairperson and members, this entity was established in terms of Deed of Trust 669/91, which is also guided by PFMA Act number 1 of 1999 as amended. In terms of the vision of this entity is a commercial-driven public sector built environment project management enterprise. Their mission, it's a built environment project management agency that manages and delivers integrated public infrastructure programs. As I said, IDT is playing a leading role in influencing, supporting, and also adding value to the national development agenda by deploying its resources in ways that deliver impact, eradicate poverty, and promote sustainable livelihoods. The entity is also therefore pursuing the following strategic objective. Number 1, provision of efficient, effective, integrated public social infrastructure delivery, as I indicated, management services, and financially viable, compliant, results-based, efficient, and focused organization. Next slide. As a background to the going concern challenges, we saying, Chairperson, that this entity was experiencing some serious going concern challenges since the financial year 2012-2013, due to the exhaustion of original 2 billion endowment which they received in 1990. The situation was further compounded by declining business portfolio over the years, particularly at the provincial government level, owing to inefficient implementation of infrastructure projects, corporate governance challenges that led to operational and financial deficits, unsustainable financial model where IDT charged a management fee at the rates that are way below the market value or market rate, and institutional incongruity, which is a trust versus Schedule 2 public entity. So this is how this entity was existing in the form of a trust, and there are also a Schedule 2 public entities, as you know it, honorable members. So failure to put into effect a business case, it became a challenge because we had to deal with that inconsistencies to ensure that there's no contradiction in terms of how this entity is being run and functioning. So what we want to indicate here, Chairperson, through these slides is the kind of financial assistance which we put as a department. So as a department, we're regularly providing financial support to this entity since 2012-2013. And I want to indicate that during that time, Chairperson, there was no allocated transfer funding which was going to this entity. So we had to look into our coffers as a department and try to see the savings which we have. We assist this entity to proceed and to deliver its mandate. So up to date, we're able to provide over 700 million to the IDT for operational cost shortfalls and the development of business case for long-term financial sustainability. But we need to indicate over the past 5 years, you can see from 2020, 2021 to the current financial year, we're able to assist these entities with the money around 343 million. And we need to indicate, Chairperson, that in the current financial year, we're not able to assist IDT, even though they were able to sort of, project the funding requirements for this particular financial year. They were looking at around 96 million, which we needed to assist them for their operational costs for this current financial year. So what we're doing as a department on quarterly basis, we're sort of assessing our budget in terms of performance and check if there are savings which we need to sort of assist the entity. But in the past three quarters, we're not able to see any money due to the budget cut, which it affected us from our main vote, which is DPWI and also PMTE. So we're not able to assist the entity in this current financial year. So they were working so hard with what they have in their coffers to ensure that they run with their operations. In terms of a turnaround initiative to address the going concern, we can report that a fully fledged board was appointed in 2021. And this board was charged with the task to develop a turnaround strategy to address the sustainability of the entity. So we see a lot of work through this board where they were able to conclude that thing, which we call a turnaround strategy or business case. As a result of various initiatives implemented by the board and the management, by the end of 2023-2024 financial year, the portfolio size has grown from 2.7 billion in 2021 to 9 billion in 2015-2016. So we're seeing a growing portfolio in terms of the business of this entity. The initial projection were that IDT required 6 billion in program portfolio to break even, based on the total staff complement of over 200. The implementation of expanded program portfolio led to further recruitments, and the IDT is currently capacitated with just over 300 employees. So the entity has worked so hard to sort of, add this capacity so that they be able to implement infrastructure projects. As a bigger organization come with greater expenditure, 6 billion in program portfolio is therefore not adequate to address the IDT going concern status. So we of a view that as a department, we need to work hard with our financial model, which we are projecting through the business case to ensure that they have reasonable resources in order to undertake this mammoth task. IDT cannot realize revenue from entire portfolio of 9 billion, as many projects are in the planning phase currently, and charges only come into effect during the implementation stage. This is one of the challenges which we foresee. The project is long to graduate into execution. We're having a lot of projects which are under planning phase, and that's where IDT needs this project to be moved into the implementation stage so that they can deliver and also charge the management fees. The IDT projected to generate 175 million in revenue in this current financial year, excluding the grant from the government, which didn't happen. This is a sign of healthy financial status, though the challenges remain. Next slide. So here, Chairperson, we put high-level assessment of audit outcome of these entities in the past years. You can see that around 2020-21, this entity was having a disclaimer. It was a time where things were not functioning in the entity. And when we brought a new board, they were able to change things around. You can see from 2021, 2022 going forward up to this current financial year, the entity was maintaining qualified audit opinion. And what we're doing as a department, we want to support them to have a clean audit, because we're having most of our entities going to that stage of a clean audit. So we're working so hard to get this particular entity to attain a clean audit as well, so that this entity can sort of move in accordance to the plan and execute its mandate accordingly, and support the mother body, the shareholder, ourselves, in terms of infrastructure delivery. But what I want to indicate before I move to the last slide is that even though you have seen in that slide that we didn't allocate anything in terms of transfer payment to the entity for current financial year, we were able to sort of support the entity in terms of our portfolio as a department, where we took some of the projects for IDT to be able to deliver the projects on behalf of the department, where we also signed the partnership agreement for them to implement also the EPWP site as well, to run the non-state sector of the EPWP where they charge management fee. So over and above the transfer, we're able to assist them in a substantive way to ensure that they be able to get some revenue. In terms of Q2 performance, the highlights which we put in terms of our assessment is that out of 108 infrastructure projects were completed against 113 planned targets. And when we assess Q3, we feel and sense that the entity should have done more, because this is when we're doing the quarterly performance review with them around November. So when we're checking their performance, and they were able to indicate intervention measures to ensure that they achieve these targets. There were 96% of projects completed within budget against 80% target. So it's a good move, because even at the side of the department, we want to ensure that projects are completed within budget and on time as well. So working on this perfection, because this is a good model of infrastructure delivered. There were 49% program contracts value, which were allocated to designated groupings against the 40% targets. And we see there was a move in this area. And there was 1,649 construction work opportunities, which were created through IDT programs against the target of 1,470 work opportunities. This is under EPWP, as I indicated, because these entities are supporting us on the non-state sector to deliver work opportunities. IDT CDP construction project tender awarded to women, 39% against the target of 40%. 84 for youth against 30 targets, so we exceeded our target there. Non-response to the bids by public works delivery areas. So these are some of the things which we were able to sort of achieve under a construction project. There is 43,983 work opportunity created through EPWP under non-state sector, excluding IDT program portfolio, against the target of 42,000. This is a good progress. And the entity also achieved a total of 2.1 million for new business generated during that period. This was a good performance, which we also commended the entity to work more on it, to generate new business. And so hence, we believe that this entity is still relevant in our area to assist our client department, national and provincial, in terms of social infrastructure delivery. The next slide. So on the issues of IDT internal controls, we have noted the lack of project management and some weaknesses around the financial management system that were not fit for purpose. So in terms of joint collaboration with this entity, we had to deal with the financial constraints around this area, because they were impacted. They also impacted the procurement of new system for improved operations. So they had to ensure that they invest in this area and come with new system to improve on the project management and the issues of a financial management system. So we have to digitize most of the things around this area, making use of technology to help us be efficient around this area. The reliability of information which were reported to the shareholder on quarterly basis, we had to deal with this because there were misaligned reports between head office and regional offices due to inadequate system. So this is the area which the entity was working on, so that there is a seamless reporting, so the reports from head office and the regions must align. The issues of financial assistance, which is provided by the department, has largely focused on operational cost shortfalls and not covering the capital expenditure. This is one of the
Sorry, Mr.
weaknesses.
Mr. Mthembeni, I'm sorry to interrupt you. We are very short of time. So we have received this presentation. The committee's received it beforehand. We are all able to read. At the moment, you're just reading through the same presentation. If you can just take us through the highlights page by page of what you want to highlight for the committee to take note of, we much appreciate it, please.
Thank you so much, Chair, for your guidance. We'll do that. I will be short. And the last part, it will be the issues of disclaimer, as I indicated, to say we are sort of seeing improvement, and there are some lessons learned in terms of dealing with the financial situation of the entity. Next slide. So here we're just putting the mitigation strategy, Chairperson. We making emphasis on the regular audits to have a lot of oversight around that, and the performance reviews. We need to work hard around these issues to help the entity to improve in their performance, and also to deal with the capacity buildings and the acquisition of systems, and make a lot of emphasis on the issue of document management, scanning, and archiving, so that we digitize the work and also integrate the system. These are some of the mitigation strategies which need to be done to attain efficiency of this particular entity. Next slide. So in terms of recommendation, Chairperson, we recommend that the portfolio committee note the challenges and interventions which we have assessed as a department regarding the solvency of the entity, and also to emphasize, Chairperson, that we're busy assisting the entity in terms of their repurposing, working with a cabinet and national treasury, and even the PSEC, which is the Presidential State-Owned Enterprise Council, which is dealing with the issues of business case, so that they be able to help us to go to cabinet to finalize the status of IDT currently, to see to it that they be able to be supported appropriately. And also note the measures that are implemented to address the ongoing concerns, and as well as the challenge of information management, which, however, IDT is constantly seeking solutions to address, and thus we need to assist them to improve in their reporting system. So that said, Chairperson, this is the part of the department in terms of the brief which you gave us to engage with you. And from there, we'll have substantive issues on the performance, AFS, which is performance and finances, through the annual report of 2023-2024. Thank you so much, Chairperson. We really appreciate it.
Thank you very much, Mr. Mthembeni. I just want to, before the RDT does their presentation, at a previous meeting that the RDT attended, of the Select Committee, I think we did ask the question, and we noted that the annual report was outstanding to Parliament. So I just want to make sure, has the annual report, including the AG report, the performance report, and the annual financial statements, have that now been tabled at Parliament yet? As we know, that's a requirement of the PFMA. So can we just get clarity of whether that report has been tabled now?
Thank you so much, Chairperson. It's a good question which you are raising. What we can indicate in terms of the report, we can indicate to say there were issues which were escalated to AGSA by the entity in terms of their assessment. That issue was concluded. Now the annual financial statements have been finalized. I should think the CEO will indicate. So what was pending is the actual tabling in Parliament, but the finalization between the parties, and AG and IDT, it has been concluded. Now it's with the department to table in Parliament in terms of the procedures of Parliament. So the tabling part is the one which is outstanding, but the matter has been concluded. The AFS have been signed off, so I can indicate as such, Chairperson.
So then I think we would, as a committee, would expect you to come back to us once you've tabled this report in Parliament, the complete report, for us to interrogate the complete report as a whole. So we will make another appointment with you then afterwards. So what I'm trying to indicate to the members of the committee is we will engage on what is in front of us today, with the proviso that we will invite the IDT back to our committee once the full report has been tabled to Parliament. Will that be in order? Mr. Mtebela?
Chairperson, it's in order, and the DG is here and also confirm, and the CEO, so that we are on the same page, all of us.
Right.
But we are aware of the processes in Parliament, Chairperson, on how we deal with the matters.
Okay, that's noted. Thank you very much. Let's move on to the annual performance report then.
Good afternoon, Honorable Chair and Honorable Members. As introduced, I'm Tebogo Malaka, and I'll be doing the presentation on behalf of the IDT. If you can do the slideshow, please. I will do the performance part, Chair, and the CFO will touch on the financial performance. I will not be touching on the slides that the DDG has done, Chair, in saving time. I will only do parts that has been left out. Next slide, please. Chair, we are presenting the annual performance of the IDT and the financial statements. You can jump the slide. The DDG has touched on the organizational context. You can just jump the slide. But as highlighted, Chair, the IDT mainly generates income from the management fees that are collected when we implement infrastructure on behalf of our different lines. You can jump the slide. In terms of the challenges, Chair, as summarized, one of our biggest challenge is with regards to the budget cuts that was introduced by Treasury. So even though, as highlighted, our business portfolio is growing, but the challenge is with regards to the expenditure. We have a high debt from our clients, and the current debt stands at 600 million, Chair. And you can imagine the management fees that we would have collected if our clients had paid us the 600 million. This is just the current debt. As we implement, the debt increase because some clients pay, some clients do not pay. And as a result, Chair, we are faced with the high litigation cost by our service providers who sue us because of non-payment, whether it's by our own doing or not. They do litigate us when our clients don't pay. Next slide. Next slide, please. Chair, the DDG did touch on the reconfiguration of the IDT. We are a Schedule 2 entity, however, we are still a trust, and the reconfiguration process has not been finalized. With regards to business generation, Chair, our business has grown. And as at the end of the year, 22-23, it was sitting at 9 billion. And it still continues to grow. However, as highlighted, the biggest challenge is that our clients are not paying us as they should. Next slide. Next slide. Next slide. In terms of our corporate performance, Chair, for the period reported, we achieved 70% of our targets, and 17% of our targets were partially achieved, and 13% were not achieved. In summary. Next slide. In terms of Program 1 performance, Chair, the only target that we could not achieve here is percentage of projects completed on time. And this target is the dependency because it depends on our clients paying us. So if our clients pay us, we are able to pay our service providers and they are able to complete the projects on time. If they are not paid on time, then there are delays in the projects. Next slide. On this slide, Chair, on outcome 2, go back. On this slide, Chair, on program 2, the only target that we could not reach here is with regards to the percentage of women contractors that are participating in the contractor development program. So when we advertised the panel for contractor development program, we struggled with the number of women, and therefore, as we allocate work to the contractors, we are struggling to achieve this target. But we are working very hard to ensure that as we open the panel, we increase also the number of women participating. Next slide. In terms of this slide, Chair, on the transformed built environment, it relates to youth contractors on the program, people with disabilities on the program, and women contractors on the contractor development program. And Chair, we are really struggling with people with disabilities, where we have even reached out to organizations to assist us of people with disabilities in terms of them participating. There is a slight improvement in this financial year, Chair, but in this particular year, we were really struggling. Next slide. This slide relates to work opportunities, both through the IDT portfolio, which is a construction, and also with regards to EPWP, and we have overachieved. Next slide. There's a continuation as well, Chair, on the challenges of us not reaching all our targets and what we are going to do to ensure that we meet our target. As highlighted, the percentage of projects completed on time, it's dependent highly on our clients paying us. However, we have changed our contracting model where our clients, some of them are giving us tranche payments so that we have money in our accounts to pay, but we are struggling with old contracts where we are still not able to collect money on time, and we are paid per invoices. Some relates to poor performance of our service providers, and we have mechanisms put in place to manage their performance through contracts where they are able to perform. Next slide. This is a split of our portfolio between infrastructure and social development, and we have 73% of our infrastructure program and 27% on expanded public works program that we are doing on behalf of the Department of Public Works and Infrastructure, Chair. This relates to the 5-year expenditure trends, and if you look at this expenditure trends, Chair, our performance have been improving year on year from 2 billion in 2021 to 4 billion in the 23-24 financial year. In terms of our program 2 on the business portfolio, Chair, as highlighted, we achieved a business portfolio of 9 billion at the end of the year. And with regards to expenditure, we achieved 87% of the expenditure because our target was 4.7 billion and we achieved 4.1. And with regards to our management fee, Chair, we had targeted 83% and we achieved 92%. The next slide, Chair, talks to the payment of invoices on time. If you look at PFMA, we are required to pay within 30 days, but because of the challenge highlighted, we have not been able to pay our service providers on time because largely due delays with our clients paying us. So we are working with our clients to ensure that we are paying our service providers on time. Chair, these are corrective measures to ensure that we are able to achieve our targets year on year. And we have mechanisms that we have put in place to ensure that we do perform. On the value of program spend, Chair, it relates to expenditure, and we continuously engage our clients to ensure that they give us tranche payments. We have monthly meetings with our clients. For us to be financially sustainable, we need to ensure that our management fee collection is sustainable, Chair. CFO, just briefly just touch on the financial performance, I think I had highlighted, just touch on what I had not highlighted.
Thank you, CEO. Good afternoon, Honorable Chairperson, honorable members of the committee, as well as the officials in the meeting. Chairperson, our financial performance is influenced largely by how fast we can convert the business that we have from our clients into project expenditure, as the CEO would have explained. And for the year under review, honorable members, we managed to spend 4 billion on projects compared to our target of 4.5 at the time. Honorable members, we came slightly short of our target under the year under review because of the challenges that the CEO would have touched on and as documented in slide 7. As a result of this 4 billion spend on projects, we managed to generate a management fee amounting to 280 million or so against, Chairperson, a total operating expenditure of 377 million. So more or less 100 million below our expenditure we managed to generate for the particular year. This meant, Chairperson, that we were able to fund our operations, 75% of our operations through the management fees. And the department then came in and assisted in trying to close that gap between our fees as well as our operating expenditure. And I'm highlighting this, Chairperson, because of its importance in ensuring that, as a going concern, we continue to at least operate and improve on our performance. As a result, Chairperson, with our management fees as well as the assistance from the Department of Public Works, we managed to contain our deficit for the year to around 8 million. Maybe just to give further context around this 8 million, honorable members, the CEO had mentioned that we face a lot of litigation from our clients, throughout the year. The total expenditure, Chair, around legal costs, as well as the values or amounts that we had to pay out in settlements in the year under review was around 47 million, which means, Chairperson, if we were to avoid this 47 million, or we had avoided this 47 million, as IDT would have made at least a profit of around 40 million in the year under review. So these litigation costs and legal fees that we incur on an annual basis really do have an impact, Chairperson, on our bottom line. Next slide. Chairperson, this slide just looks at our cash position as at the end of the year under review. Chair, you will note that we had a balance, a bank balance of around 53 million. Unfortunately, 15 million of that was funds that we had held on behalf of clients, i.e. these are funds that we had not expended as part of our project implementation, which means that our own bank balance at the time was sitting at around 39 million. Chairperson, if you compare that to the previous year, it had come down to by another 15 million. So we were affected really again by the deficit that we then incurred, as well as all of these legal costs that we incurred during the year under review. If we also look at a particular line item in our financial statements where our cash is held up, Chairperson, is around the trade and receivables. At face value, Chairperson, we were owed about 73 million by our clients as at the end of the year. However, because of the long outstanding debts that the CEO again referred to, where our clients took long to pay us, we had to basically provide for impairment 55 million of that 73 million, which is a substantial amount, Chairperson. In other words, we were saying from what we are owed as IDT of 73 million, 55 million of that we expect not to receive. So we had to provide as required by
the accounting standards, or at least the reporting framework that we use to come up with our financial statements. And maybe, Chairperson, adding to that particular cash constraints is another 41 million which we owed to our creditors at the same period, or during the same period, Chairperson. Next slide. So, as I mentioned at the beginning of my presentation, honorable members, there is a link, a direct link between our own performance or financial performance and what happens in the project space. I've just mentioned the receivables, or at least the debts that we are owed by our clients, Chairperson. That is for our own account as IDT. That is then linked, Chairperson, to a 2.3 billion, which our clients was then owing us, and as a result, we were then owing our service providers at the end of March 2024, which means, Chairperson, we could not at the time pay our service providers to the tune of 2.3 billion. And again, it was because we are still waiting for funds from the department. And Chairperson, maybe for the members to note, this is a trend towards the end of the year, of each financial year, where our client departments deplete their funds, but we continue implementing projects in the fourth quarter. And therefore, you then see this the balance that we are owed by our clients ballooning in the fourth quarter, because when they run out of funds or budgets, honorable members, we don't stop with the implementation of our projects. But what that means is that for 3-4 months, we then owe our service providers as we wait for the new financial year, and our clients receive their new allocation and therefore pay us, in order to make up for what was owed at the end of the financial year. Next slide. Next slide, please. It hasn't moved on my side. Through you, Chair, am I still audible? Oh, there we go. So, Chairperson, I think this table here, it just demonstrates, what the CEO again. Previous slide, please. The previous slide with the table of payment turnaround. There we go. Honorable members, I think this slide, it just provides further insights on what the CEO had mentioned earlier about how we are required to pay service providers within 30 days. And as much as we can, we do pay our invoices within 30 days. But obviously, this is based on what we would have in the bank account, honorable members. So if you look at the project space, also called the program budget, out of the 11,000 invoices that we would have received over the year, we managed to pay about 50% of those within 30 days. And those that we had to negotiate and pay after 30 days, and those that were not paid at the end of the financial year, are then linked to the 2.3 billion I mentioned in the previous slide, Chairperson. So, and then when you look at our own overhead invoices, it's a similar picture, where at the end of the year, we owed about 40 million to our creditors, and which was around 1,200, 300 invoices that we could not pay within 30 days, as at the end of March 2024. Next slide. The next slide, Chairperson, which is still coming on my side, it's my last slide, and really, it is just to update this particular committee, Chairperson, on the status since our last appearance. And you did ask the question before we started with our presentation in terms of where we are with the audit process. Chairperson, we did finalize eventually the audit report, and the AG signed it on the 13th of Feb, which was around 2 weeks ago. And in that particular audit report, we maintained the same audit outcome as last year, which was a qualification. And it is still work in progress, Chairperson, where we are working towards, unmodified audit outcomes for the entity. And that's what everyone is working towards going forward. Chairperson, I think let me pause there in the interest of time. I see that we've exceeded our allocated time slightly, but I will then ask the CEO to just touch on the last couple of slides, honorable members. Thank you very much.
Please continue.
Thank you. Briefly, Chair, with regards to the governance matters, we had a functioning board as at the time of reporting, and meetings of the board were held as per statutory requirements, and all the board committees also met. Next slide. Chair, I'm not going to touch on the dates as highlighted. All the committees met. Next slide. Next slide, please. Chair, we are recommending that the Select Committee notes the IDT's performance for the 23-24 financial year. And thank you, Chair.
Thank you very much for that. Honourable members, we are a little bit short of time, but I'm going to allow some time for engagement with the department and with the entity. So let's have a show of hands, please. Honourable members, are you still on? There we go. Honourable Teza, I see your hand. Honourable Skeerkogel, I see your hand. Okay, let's start with that. Thank you, Honourable Teza.
Thank you very much, Chair. I will begin with the last presentation. They are talking about the 2023-2024 audit outcomes, getting another qualification. Remember that in 2021, they had a disclaimer, and then 2021, 2022, 2023, 2022, 2023, the qualifications. And the qualifications, which is the fourth qualification now. So what systems have you put in place to ensure that you move towards a clean audit? And what are the findings of the Auditor General, if you have them at your disposal for the last financial year and this year, so that we see whether there could be issues that you did not address that stagnates you to a qualified audit. The other issue, Chair, relates to the IDT. The challenges within the IDT in terms of infrastructure delivery and the payment within the 30 days that you are allocated for as a result of not being paid the monies that are owed to you. So my question there is, who is responsible to ensure that the amount that you are saying that it was spent, the 40 million was spent on litigations? Who is responsible for, I didn't get it, responsible for avoiding that money from being spent there? in terms of your clients having to take you to court and incur costs as a result of that process? Who is responsible to make sure that this whole dispensation does not occur, so that money is saved in terms of your budget? And why has the department not funded you in the year under review? What are the impediments to having now you being funded? Those are the 2 questions that I have, Chair. Thank you so much.
Thank you very much. Let's go over to the department. Honorable Kaunda, I see your hand. I'll take your hand after this round of questions. We're just going to, Honorable Skierkogel, just WhatsApp me, he's taken a body break. So you'll go next, but let the department first address the questions from Honorable Kleza, please.
Thank you very much, Honorable Chair. The question was, what systems have we put in place to move to a clean audit? Chair, we have currently procured a project management system that will assist us to ensure that our audit moves swiftly with regards to documents, filing, management of projects on site. At the click of the button, you will then be able to get the information that AG would require for them to be able to audit. So this system will assist us in terms of addressing some of the findings that AG raised with regards to the management of our projects, because the issue of the system was also one of the findings with regards to the AG. So we are internally working to ensure that this system is fully implemented to ensure that our projects are monitored in line with applicable legislations, and also the issue of records keeping. Everything will be put on the system. With regards to the second question on infrastructure delivery and versus the 30-day payment and who is responsible to ensure that money spent on litigation is recovered. Chair, our service level agreement states clearly that if the litigation is as a result of our clients not paying us, they will be responsible for paying for the litigation. However, Chair, you find that we are taken to court and sued now, and the department has not paid us. So IDT will then incur the cost of that litigation and later claim from the department, which is still a challenge, because by that time, the client has still not paid you for that litigation cost. And we go to court knowing very well that we do owe the service provider, we are going to lose the case. But unfortunately, in terms of our legal system and justice, we have to present the case to court. So the cost of bearing that litigation still goes to that client, Chair. Thank you.
Thank you. Preza, are you covered by that?
Thank you, Chair. With regard to the question directed to the department raised by Honorable Nteza around the impediments for financial assistance for IDT in the current financial year, as I indicated, Chair, the biggest challenge we had from the department point of view is that there was no allocation for the medium-term period directed to IDT by National Treasury. So year on year, we just check the expenditure trends and the savings which we have as a department, and we start to allocate the entity. So as I indicated, in the past quarters, when we're doing the quarterly reviews of our finances, there were not savings which we're having, which we can sort of, transfer to the entity. So that was the reason we kept on checking to say, what is it that we have, where the budget is not moving, so that we assist the entity. So in the past quarters, we couldn't have that, but safe to say that the only assistance which we did to the entity, it was on the projects themselves through the portfolio which we have, where we allocated some projects to be implemented by a entity so that they be able to charge us the management fee so that we support their existence and so forth. And also on the non-state sector, EPWP side, where they implement the program and charge management fees. But on the operational cost, there were no money from the department which were to support them for the current period. Thank you so much, Chairperson.
Thank you very much, Mr. Mtumbeni and Ms. Malaga. Honorable Pleza, are you covered by that?
Not really, Chair. I just wanted the department to answer, to clear me or balance me or assist me on the litigation costs that are incurred by the IDT and the protracted nature of back and forth having to go back to the department to rely on it to be able to pay the costs and therefore avoid the entire dispensation of litigations, saving the entity a huge amount that would have been paid to litigations.
Thank you. I'll allow the department to address that.
Thank you, Chair. Thank you, Honorable President. I should think the back and forth on the litigation cost is not a litigation which is directed to Department of Public Works and Infrastructure, but it's a litigation cost of other client department where our entity is having an agreement to implement their projects. So when they come to us, we are assisting them with the monies to sort of deal with their operations. And some of the operations, it might be litigation which are not directed to Public Works, so that they have a cash flow to deal with that. So the back and forth is not directly to Public Works, but it's other clients where they're executing on their behalf. Thank you, Chair.
Thank you very much. Honorable Kaunda.
Thank you very much, Honorable Chair. Let me join my colleagues to welcome the report and also support the narrative that you have shared with us, especially on the submission of the report to the NA, National Parliament. Chair, my first one is on what strides have been put on the austerity measures in terms of identifying the items, and if they can share with us few of those items to try and reduce cost in the entity for its own survival. Around those items is the issue of the rentals. Are we renting buildings in a period of 5 years? How much rental fees have we paid? Because that will also give us the figure if we own land and build a building, how far would have gone in terms of saving monies. Lastly, Chair, is the issue of building internal capacity within the institution, and also making sure that the issues of SCM, when these projects are implemented, we also conduct thorough negotiations with service providers, because my experience in government is that we accept all prices that come before our eyes. As a result, you find that government is paying for things, if you look at the bill of quantities, for things that we are not even supposed to be paying so much amounts on. So it's very important that we try and save the limited resources at our disposal. Thank you very much, Chair.
Appreciate that. Department, your answer, please.
It's IDT Chair that will answer. Chair, we have put in austerity measures, and the CFO will touch on that. We have reduced our traveling costs. Meeting with the regional offices is done virtually. As you know, Chair, we have offices in all the provincial 9 provinces, and these offices are being rented in the provinces. However, the national office owns the building. However, because due to our financial position and challenges, Chair, we are really struggling to maintain that building as well. So it has serious compliance issues that we are currently dealing with together with the department, looking at the option of the department assisting us with office accommodation for national office because of the state of that office. With regards to rentals in the provinces, Chair, some of the provinces are renting accommodation. Some of them are housed in the provincial Department of Public Works, where Department of Public Works is not able to accommodate us in their offices. We are then forced to rent offices. And then where the province is not generating enough revenue to sustain itself, we then merge with the neighboring province, Chair. The question on building internal capacity, Chair, relates to one of the issues that I raised as well, to say that we have procured a system that will assist us in building our internal capacity. So monitoring of projects is done efficiently with the system. When the project managers are on site, they are able to load pictures on the system, submit reports on time on the system. But also with regards to SCM, we do negotiate with some of our service providers where it is feasible. It's very few of those, Chair, I must say, but where possible, we do negotiate on prices with our service providers, not compromising the quality of the end product that we are expecting. Maybe CFO, we can just touch on additional austerity measures over and above the travel and the catering that we cut cost on.
Thank you very much, CEO. Maybe just to add, Honorable Member, there's about 5 areas that we are deliberate in terms of, curbing our expenditure. One of them being the employee costs. We have had to take a decision to say, look, as much as all our vacancies are important, some are more critical than others. So we've sort of had a moratorium around the appointment of new people, as well as filling in of vacancies. And so that, only those that have been deemed critical positions are then filled. And this is done through the office of the CEO. The second one is around the travel itself. We've had to say from an admin point of view and admin travel point of view, we try and eliminate admin related travel, but what we cannot obviously stop, Chairperson, is travel to visit sites of our projects which we implement, because they also contribute towards travel. But even in those instances, we've come up with very strict criteria in terms of when that particular travel can be implemented by the project implementers. The third one, Honorable Member and Chairperson, is around this legal cost issue that I mentioned earlier. Again, we've undertaken a drive where we go back to our clients and really be aggressive in terms of ensuring that we try and recover as much of these legal costs that we've incurred on their behalf in the past. And going forward, we try and hold their hands as soon as we get litigation letters. We then go hand in hand with our clients as we approach the court processes, so that they know that we are embarking on a process where we are defending a case that we should have avoided if they had paid us the project funds on time. The fourth one is around the internship programs that we implemented IDT. Unfortunately, we also had to relook at some of our interns that we bring in and support and train honorable members. Obviously, this has an impact in us, training new graduates around the infrastructure sector, as it were. But without the retained funds that we have, or at least in our bank account, it becomes difficult for us to then continue bringing in as many interns into our program as possible. And I think the last one, CEO, you touched on it, which is the catering. It is part of our processes that when we hold meetings and briefing meetings, we sort of have a budget around catering and meals around those. We've tried to also cut down on those. And then for meetings, all our staff, I encourage that we will no longer be providing catering and meals, even if it's official meetings that have been called chairperson. So we are indeed implementing some measures which contribute towards our operating expenses. And we've also cut down, lastly, in terms of the operating budgets for all our units, which will also then go a long way in ensuring that we minimize our operational expenditure. Thank you, Chairperson.
Thank you very much. Honorable Kaunda, are you covered?
Yes, thank you, Chair.
Much appreciated. Thank you very much. Honorable Skeerkogel.
All right, can you hear me?
I can hear.
Yes, all right. Thank you, Chairperson. Let me go into this. All right. I just want to find out, like, there's been a lot of controversy about why the board has not been able to sit and they're not curated. But why did the board of directors for the IDT not make any attempt to appoint people or to send notice to the minister to do that? Because it's able to function and to get a legal opinion based on Section 10 so that it can function. And or if they don't curate under Section 10 of the trust, the deeds trust, to be able to complete the financial statements and then put forward numbers, why did that not happen so that it can happen? Then could they maybe, I think there was mentioned in the report, but do we actually know how much money do we have in the accounts? And then it says that we're not able to function and then projects have to stop. So, but you still continue. Don't we see that is why we keep on having legal actions? Shouldn't the department follow a proper business plan? So when the departments don't pay, then stop it. So why is not happening? And why can we not get a breakdown of which is the culprits of this? And then they said that the IDT's portfolio went from 2 billion to 9 billion. Can we explain how and where did that happen? And then just looking at all the things of constantly having to ask for bailouts, and the IDT is not supposed to have bailouts. Don't we think that it makes sense that the IDT to exists under a mandate that it was created in 1990 it's not recognized anything? And then why should this entity IDT not be absorbed by the Public Works and Infrastructure Department to do the same thing? And then I remember I asked in my last question in our first engagement in 2024 with the select committee that the IDT must submit a business plan. And I don't recall that we've received any business plan. Thank you, Chairperson.
Thank you very much. I think those are all directed at the IDT.
Chair, on the question of the board and the governance issues, I will leave it to the DDG to respond on that. But IDT did write to the minister and inform him of the resignations. On how much is in the bank account, the CFO will respond. The other question was on who are the culprits who owe the IDT. So, Chair, we have the Department of Education across the different provinces. We have Department of Health. We have Department of Higher Education. We have Department of Social Development. We have Department of Justice and Department of Correctional Services and Economic Development owing us. We have submitted the departments and the amounts that they owe to the Portfolio Committee on Public Works and Infrastructure. The business stands at 9 billion due to additional clients that we have engaged. We have the Department of Transport, and over and above the Department of Transport, we have the same clients who each year will do their allocation. So as they do their additional allocation, it increases our portfolio. The challenge is on the expenditure of the 9 billion. It is then across the third quarter that they will then start saying we must slow down on the implementation as they are running out of funds, and then they give us funds in the next financial year, which will be April. However, during that current financial year, it will create a deficit. Chair, the question is, why do we continue then implementing when we know that the department will not pay us? There are service providers who will have the cash flow to wait until the next financial year to implement. And the cost of stopping and then going back outside becomes higher when we do stop. So if we stop, when the service provider goes back on site, they will still charge establishment cost, extension of time cost. So to balance and saving government money, we then weigh the pros and cons of stopping and continuing. And you find that in some instances, it's in a province where the structure is so dilapidated that if you stop, it then affects the livelihood of that community that you are servicing. So it's a very tricky circumstance, Chair, that we find ourselves in. So it's not really an easy decision to take in that instance. Where the project is not that critical, we do stop and highlight to the client that, however, when we go back on site, the cost of that project would have gone higher. And that's why you find that some of our projects are not completed on time, Chair. I will leave the two questions to the CFO and the DDG. Thanks, Chair.
Thank you, CEO. Through you, Honorable Chairperson. The question on the cash balance, Chair, if we go back to slide 24 of our presentation, I had mentioned there, Chairperson, that as at the 31st of March, because a bank balance is a balance sheet item, and therefore you need to look at it as at a particular period. So in terms of the financial statements for the year under review, our bank balance then was 53 million. I also indicated, Chairperson, that 15 million of that is not necessarily IDT's money. So those are funds that we had held on behalf of a particular client or some of our clients. So what they do when they transfer funds, they would transfer them into IDT's own bank balance, and then we distribute them accordingly to the different programs. So in effect, our bank balance as at that date, if you go back to slide 24, Honorable Chairperson and Honorable Member, we were sitting at a net bank balance of 38 million. Now, we also don't look at that in isolation, Chairperson, because I also indicated that as at the same day, our creditors were sitting at 41 million. And that was not even taking into account, salaries, which is our biggest line item from operation. So even at that point in time, we had less cash than what we owed our creditors. And that's the overall picture when we then look at the bank balance. Otherwise, Honorable Chairperson and Honorable Member, the bank balance really fluctuates on a daily basis. So I can give you a figure from today, which will be different to tomorrow and different from yesterday, because we pay our our service providers as well as collecting. So it depends on a particular day. Thank you, Honorable Chair.
Thank you.
Yeah, thank you so much, Chairperson. Responding to the issues of controversy around the board as raised by Honorable Skiervogel.
Yes, please continue.
What we need to indicate, just to assure our members, the issues of stabilizing governance for the entity, the minister has attended to it. On the 12th of February 2025, Minister made appointments of ministerial representatives in terms of the provisions of deed of trust. So the two members were appointed just to stabilize the board. The expectation is that following that appointment, the board will be able to submit to minister the list of candidates that will fill the remaining vacancies. So things are in the process. So minister will be receiving that list to make a determination. And again, additionally to that, we are aware that this current board will run up to July. So minister approved a process where we need to start with the nomination of the new board, starting from first week of March, where we'll put adverts to seek for nomination, so that there be seamless process. When this board come to the end in terms of its tenure, the new board will sort of, be in place as well. So that's how we can respond as a department to deal with the stabilization of a board and to ensure proper governance. Thank you so much.
Chairperson, if I may be allowed to respond to the question around the IDT mandate.
Sure, thank you very much.
Yes, Chairperson, greetings. It's Mpoma Shaba, Director Public Entities. The IDT is not operating on the mandate of 1990. It is operating on the mandate of 1997. IDT, when it was established as a funding agency to fund social development programs. And gradually, IDT grew into a social infrastructure implementing agency. And when Cabinet noticed that that the IDT had entered that space, then in 1997, Cabinet determined that the IDT shall be a social infrastructure implementing agency, implementing government projects. So as such, in 1999, it is when IDT was established, was actually scheduled in the PFMA as a Schedule 2 public entity. However, the challenge was the fact that even though that conversion to a Schedule 2 entity was made, the issue of the trust was never addressed. As such, we are having that incongruency of having an entity that exists in two forms. But just to confirm that the IDT mandate was changed by Cabinet in 1997. Thank you, Chairperson.
Honourable Skirkhoff, are you covered?
Yes, thank you, Chair. Now I look forward to the engagement in July when we hear about the board. My next question that wasn't answered, the IDT business plan that needs to be completed.
Could we get maybe just a short answer on the completion of the IDT business plan?
If I may also respond on that, Chairperson. Just quickly, we went through a whole process where we were working with the GTEC in order to develop the business case, and we were able to complete it in 2022, and then in 2023 we presented to the Presidential State-Owned Enterprises Council in accordance with the Cabinet resolution of 2022. However, the PSEC, Presidential State-Owned Enterprises Council, had a challenge in getting the services of an analyst to analyze our business case and also analyze the operating model of IDT. The delay was up until the PSEC submitted its own report to the Presidency, and unfortunately that meant that the submission didn't have an expression on IDT. So therefore we have a challenge in going back to Cabinet with the business case, because now since the cabinet determined that the process must be done in accordance with the PSEC process, but we don't have a report from PSEC, we are now in that situation, a sort of a limbo situation as to how to proceed forward. But the minister has made an undertaking that during the current financial year, he will address that particular issue. So we await the minister's directive in that regard. Thank you, Chairperson.
Thank you very much. I do have a few questions, but we've run out of time. So I will reserve most of my questions for the future engagement we're going to have once the full report has been presented to Parliament, and we can have the time slot. And I suggest to my committee secretariat that time slot that we have at our next engagement will be specifically reserved for the IDT, so we can interrogate. There's a few things I'd like to look at, the findings of the Auditor General, et cetera, et cetera, et cetera. There's a few issues we need to address. Just quickly, short answers, if you don't mind. I think in your presentation, Ms. Malaga, you mentioned something about the reconfiguration. Is that the progress, the changing of the IDT into a Schedule 3A entity? And if it is, just quickly, what are the hold up there? Why is that not happening? That's the one question I want to ask to the IDT. And then the other question to the department, in slide 6, I've noticed you've provided 343 million rand of taxpayers' money to the IDT since 2020-21. Would the department say that it got bang for its buck? Did it get value for its money, spending that amount of money? Thank you very much.
Thank you, Chair. The reconfiguration that I highlighted in my presentation is exactly what Mr. Mashaba related to with regards to the process of the GTEC, Chair. That is the same process, Chair. Thank you.
Thank you.
Thank you, Chair. On the other question you posed to the department on value for money for 343 million, which we gave to IDT over the years. I should think from where we're sitting, Chairperson, there was a value addition in terms of the resources which we supported this entity, because it affirmed the mandate of the department in terms of infrastructure delivery and their flexibility in terms of how they execute projects. They were able to assist. Safe to say that hence we support the processes which are underway to repurpose them so that they can sort of do more in their mandate, and also to support public works mandate, because currently in the department, when you look into our line function, we don't have a dedicated capacity to deal with the delivery of social infrastructure at the national level. So IDT is helping us around that area, working with our provincial counterpart. So yes, we can confirm that there was value for money, for the money which we supported the entities to still stand. Otherwise, if we didn't do so, the entity should have closed down. Thank you so much.
Thank you for that. I really appreciate the department. I want to apologize because we crammed you into a meeting today that needed a lot more engagement from our side, and I'm looking forward to our next engagement. So thank you very much, Mr. Mtembeni. Thank you, Ms. Malaga. Thank you, Mr. Songwebu, and the rest of the department and the entity. I really appreciate you being available today to meet with our committee, our select committee, and we look forward to the next engagement. Members, it is exactly 1 o'clock. I'm going to let the adoption of the minutes of the previous meeting stand over to our following meeting. With your indulgence, I'm aware that there are other engagements to follow after this meeting. So without further ado, with a lot of thanks to the departments and to our staff, I'd like to declare this meeting closed. Thank you for your attendance.
Thank you very much, Honorable Chair. Good afternoon.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Recording stopped.